Get ready. 3, 2, 1, start. The respondent was appointed as a civilian clerk in the army in the erstwhile state. In the state, the age of superannuation, as prescribed by the regulation of the State Civil Service Regulations, was 62 years. The Prime Minister of the state and the rulers of other states enter into a covenant whereby they agreed to unite and integrate their territories in one state to be known as the new state. As a result of the integration of the services of the Union States, the respondent was posted as auditor in the Treasury in the state. On the coming into force of the Constitution, the state became a state and continued as such. The reorganization of the states under the States Reorganization Act 1956. The state of the new state became a part of the reorganized state of Punjab, and the respondent was absorbed in the service of the state of Punjab. As a result of the reorganization of the state of Punjab and the formation of the state, the respondent was allocated to the state. He filed a suit in the Court of Sub Judge for a declaration that his retirement at the age of superannuation was illegal and against the service condition, and that he was entitled to continue in service up to the age of 62 years. The said suit was dismissed by the trial court on the view that the state service rules were not applicable and the conditions of service of respondent were governed by the rule of civil service rules, which prescribes 58 years as the age of superannuation. The said judgment of the trial court was, however, reversed in appeal by the additional district judge, who held that the age of superannuation constitutes a condition of service, and by virtue of the clause of the covenant, the said condition continued in operation in the state and thereafter in the state of Punjab in view of the States Reorganization Act, and in the new state in view of the Punjab Reorganization Act, and it has not been shown that approval of the central government had been taken for applying the provisions of the civil service rules to the respondent. Second appeal filed by the appellant state against the said judgment and decree of the additional district judge was dismissed by the High Court by the impugned judgment. Hence this appeal. The question that falls for consideration is whether the provisions of the state service regulations, which prescribed 62 years as the age of superannuation of persons employed in the state service, continued in operation after the formation of the state and thereafter the state of Punjab and new state. For a proper appreciation of the submission of the learned counsel, it is necessary to take note of the relevant provisions of the covenant. Stop.